and policies implemented by the occupying power in occupied Palestinian territory do not comply with the elementary obligations of international human rights law or international humanitarian law. The court already confirmed this in 2004 with respect to the construction of the wall. However, the colonization of occupied Palestinian territory, including East Jerusalem, and the installation of settlements with the aim of achieving lasting demographic change, and the displacement of Palestinians, the destruction of their houses and their property, have but accelerated. The Court, the General Assembly and the Security Council have recalled that settlements in occupied Palestinian territory have no legal basis and remain illegal. The Council vigorously regretted for a long time the continuation and persistence of Israel in pursuing those policies and practices. The written and oral statements of participants in the instant advisory proceedings have also demonstrated that the practices and policies of the occupying power are not consistent with what is required of it under international law. All these violations of international law arising from the prolonged occupation compromises the effective exercise by the Palestinian people for its right to self-determination and the achievement of a two-state solution, to which the Republic of Slovenia remains profoundly committed. Distinguished members of the Court, every internationally wrongful act of a state entails the international responsibility of that state. That key provision of the Articles on State Responsibility for Internationally Wrongful Acts contains in itself a part, an important part indeed, of the answer to the question of the legal consequences of the policies and practices which are before you. Israel has engaged its international responsibility. The content of the international responsibility of the State of Israel, or to use the terms of the ILC, the legal consequences involved by this responsibility, are enumerated in Articles 29 through 32 of the Articles on State Responsibility. Israel has the obligation to put an end to its internationally wrongful acts and to all the practices preventing the Palestinian people from fully exercising its right to self-determination. First and foremost of which are the prolonged occupation and annexation of Palestinian territory. Israel must fully carry out its international obligations, in particular its obligation to respect and promote the self-determination of the Palestinian people in the full compliance with international law. The harm caused by these internationally wrongful acts must be fully repaired. Implementation and compliance with these applications arising from the wrongful acts are not only due to Palestine and to the Palestinian people. On account of the erga omnes nature of the rules and obligations breached, which rules are due to the international community as a whole, any state without distinction is entitled to invoke Israel's responsibility. Any state can require the cessation of violations and compliance with the obligations in question. Any state is entitled to require the implementation of the obligation of reparation in the interest of the Palestinian people and the state of Palestine. As the Court recalled in the Barcelona Traction case, in view of the importance of the rights involved, all states can be held to have a legal interest in their protection. Mr. President, as far as states other than Israel are concerned, and doubtless the United Nations too as an international organization, this isn't merely about summoning Israel to cease its wrongful acts. States do not only have a legally protected interest that Israel respects the right of the Palestinian people to self-determination. All states also have the duty, and the duty is to promote through joint and separate action, realization of the principle of equal rights and self-determination of peoples in accordance with the provisions of the Charter, and to render assistance to the United Nations in carrying out the responsibilities entrusted to it by the Charter regarding the implementation of the principle. And that is rehearsing, you will have noted, the terms of Resolution 2625 for the General Assembly. In the same fashion, under the terms of Article 1, which is shared in all the 4 Geneva Conventions, the contracting states not only committed to respect the obligations arising from these treaties, but also to ensure respect of these obligations in all circumstances. The practices and policies impeding the realization of the right to self-determination of the Palestinian people cannot exempt the other states and the United Nations from these obligations. On the contrary, in the presence of the illegality of these practices and policies noted time and again by the principal organs of the United Nations, including your court, we must be able to count on the members of the United Nations to draw all attendant consequences and to implement the obligations falling to them pursuant to the Charter and international law. So that would imply for all states and for the United Nations to take the necessary measures to put an end to the tragic and above all illegal situation facing the Palestinian people, and which has faced them over decades. The General Assembly has recalled time and again and has urged all states and the specialised agencies and organisations of the UN system to continue to support and assist the Palestinian people in the early realisation of their right to self-determination, independence and freedom. Furthermore, on account of the nature of the obligations in issue and their importance, states are not only held to cooperate to bring an end through lawful means these serious breaches, they are also under the obligation to not recognise the situation created by these breaches and must abstain from rendering any aid or assistance in maintaining this situation. The Court has already confirmed the relevance and existence of legal consequences for all states in its 2004 advisory opinion, and the General Assembly has requested all states members of the United Nations to comply with their legal obligations as mentioned in the advisory opinion, including those consistent with their obligations under international law and the relevant resolutions not to recognise and not to render aid or assistance in maintaining the situation created by measures that are illegal under international law, and to not aid them in this end. In order to comply with these obligations, all states must inter alia distinguish in their relevant dealings between the territory of the State of Israel and the territories occupied since 1967. As the Security Council recalled in its Resolution 2334 of 2016, referring all the while to your advisory opinion. Mr. President, distinguished members of the Court, the painting by Paul Albert Besnard, which hangs in this great hall, recalls the cardinal principle of contemporary legal order: peace by justice. The Republic of Slovenia is firmly convinced that the scrupulous respect of international law, where the court is the principal judicial organ, can put an end to the unbearable and unacceptable situation in the region and work for a just and lasting peace in which every state in the area can live in security. Mr. President, these words close the oral presentation of the Republic of Slovenia, and on behalf of our delegation, I would like to thank you for your kind attention.
I thank the delegation of Slovenia for its presentation. I invite the next participating delegation, Sudan, to make its oral statement before the court and call upon Mr. Marwan Khair to take the floor.
President, distinguished members of the Court, it's my honor and privilege to address the International Court of Justice on behalf of the Republic of Sudan. I express gratitude to this Court for extending the opportunity for my country's participation in these advisory proceedings on the legal consequences arising from the policies and practices of Israel in the occupied Palestinian territory, including East Jerusalem. The Sudan is present here today, owing to the profound significance of these proceedings in the context of realizing the inalienable right of the Palestinian people to self-determination. This matter has persisted on the United Nations agenda for several decades. The dire circumstances prevailing in the occupied Palestinian territory over the past decades, compounded by the current severe humanitarian crisis in Gaza Strip, underscore the profound jeopardy facing the fundamental rights of all people in the Middle East, particularly the Palestinians. Therefore, these oral proceedings assume critical importance in persuading the Court to exercise its jurisdiction and accept this request for an advisory opinion. The Sudan contains that such a stand by the principal judicial organ of the United Nations would convey a definitive message to both Israel and Palestine, urging them to redouble their efforts in achieving peace and security for the mutual benefit for their peoples. Moreover, the Sudan maintained the perspective that, in giving this advisory opinion, the Court would assume a crucial role in fostering justice, peace, and security, not only in Israel and Palestine, but also in the Middle East and beyond. Mr. President, in accordance with the rules of court, we will address the statement specifically to the issue that, from the perspective of the Sudan, remains a point of contention among the participants in these proceedings, whether or not the Court should give the requested advisory opinion. The statement will be as succinct as possible within the limits of what is necessary for adequate presentation of the Sudan's contention at this hearing. Mr. President, I respectfully invite you to give the floor to Professor Raimondo, who will proceed with the delivery of this oral statement. Thank you, Mr. President. Thank you, members of the Court.
I thank Mr. Khair. I now give the floor to Mr. Fabian Raimondo. You have the floor, sir.
Mr. President, distinguished members of the Court, it is my privilege and pleasure to stand before the International Court of Justice today to address the issues of jurisdiction and admissibility of this request for an advisory opinion. The articulation of objections to the admissibility of a request for an advisory opinion from the General Assembly is not an uncommon occurrence in proceedings before this Court. Nevertheless, the Court has consistently dismissed such objections. In the subsequent discussion, I shall initially recall the consistent jurisprudence of this court on the issues of jurisdiction and admissibility. It is within this body of jurisprudence that the court can find the resolution to the objections raised concerning the admissibility of the current request for an advisory opinion. As pointed out by this court in the Chagos advisory opinion, I quote, "When the court is seized of a request for an advisory opinion, it must first consider whether it has jurisdiction to give the opinion requested, and, if so, whether there is any reason why the court should, in the exercise of its discretion, decline to answer the request." Unquote. The jurisdiction of this court to provide an advisory opinion stems from Article 65, paragraph 1 of its statute. This article provides that the court may give an advisory opinion on any legal question upon the request of any body authorized by or in accordance with the Charter of the United Nations to make such a request. The General Assembly has the authority to request an advisory opinion according to Article 96, paragraph 1 of the Charter of the United Nations, and this article stipulates that the General Assembly has the power to ask the International Court of Justice to provide an advisory opinion on any legal question. In these proceedings, the court is first asked to determine the legal consequences arising from the ongoing violation by Israel of the right of the Palestinian people to self-determination from its prolonged occupation, settlement and annexation of the Palestinian territory occupied since 1967, including measures aimed at altering the demographic composition, character and status of the Holy City of Jerusalem, and from its adoption of related discriminatory legislation and measures. Next, the court is asked how said policies and practices affect the legal status of the occupation and what legal consequences ensue for all states and the United Nations from this status. Mr. President, members of the court, it is evident that these questions concern the legal consequences of violations of international law that have been recognized as such by the Security Council and the General Assembly, among other United Nations organs and bodies, as well as to the legal status of the occupation in view of those violations and the legal consequences of its illegality. The General Assembly requests the Court to answer these questions in accordance with, inter alia, the rules and principles of international law, international humanitarian law, and international human rights law. For these reasons, the Sudan believes that the request has been made in accordance with the Charter and that the questions submitted to the court are legal in character. I shall now proceed to the issue of the admissibility of the request. As recalled by the court in the Chagos advisory opinion, I quote, "The fact that the court has jurisdiction does not mean, however, that it is obliged to exercise it," unquote. According to consistent jurisprudence of this court, the discretion whether or not to respond to a request for an advisory opinion exists to safeguard the judicial function of the court as the principal judicial organ of the United Nations. However, the court is aware that its reply to a request, I quote, represents its participation in the organization and, in principle, should not be reviewed.
All right, so you're taking a listen as countries are addressing the World Court on Israeli policies right there. This, of course, is the International Court of Justice, and this is the 5th day of public hearings to allow countries to present their views on the legal consequence of Israel's occupation of the Palestinian territories.